So I just want to give you a little overview of our agenda for the evening. We have Mr. Ben Colombo here. He is the Interdepartmental Liaison for North Bklyn for the Department of Buildings. We also have Mr. Wojciech Jackowski, who is an excellent construction lawyer who's going to be going through some of the construction license agreements and what should be in a proper negotiation in that agreement so that you can protect yourselves. And hopefully if our representatives show up, then we will be able to get an idea from them on the legislative policies that they are currently working on, as well as what they hope to create to help protect homeowners before the process of adjacent development begins, as well as those who are currently in trouble. So we're going to hear first from Mr. Ben Colombo. And I'd just like to ask you all to reserve your questions until we get to the Q&A so we can get through these presentations quite quickly, and then we can have a wider conversation. So if you can remember them, write them down, please do so. All right, thank you.
Hi, good evening everyone. As Veronica said, my name is Ben Colombo from the New York City Department of Buildings. Actually, do I need the mic?
No.
No? Great. I tend to project. So again, my name is Ben Colombo. I'm here from the New York City Department of Buildings. I'm in the Intergovernmental and Community Affairs Unit. I've been asked here tonight to kind of detail the permitting process. Now this process is slightly different for each type of permit, but tonight I figured it would be best if I spoke about demolition permits and new building permits. So we'll start with demolition. Any application that comes to the Department of Buildings needs a plan review, except in the case of demolition, where it's not the kind of detailed plan review that you would have with a new building. With demolition, what we're looking at is how you plan to demolish the building, whether that be by hand or by mechanical means, and that the necessary safety steps have been taken beforehand. So when an applicant applies for demolition, they submit the application to our BEST unit, which is the Building Enforcement Safety Team. And they really are in charge of demolition applications. So they'll review the plan, see how the contractor plans to take the building down, and then there's a checklist of items the contractor must provide. So this includes notification to adjacent properties. They'll generally send you a piece of certified mail for all properties adjacent to the building to be demolished, stating that they intend to demolish the building. We collect those certified mail receipts as proof that they've notified their neighbors. There's several other items. We need proof that all utilities have been cut off, proof that a pest control contractor has been contracted for the duration of the demolition. So utilities, we need pictures of the property before demo, and then we do a pre-demo inspection. An inspector from the BEST unit goes out, looks at the building, visually makes sure it's okay to be demolished, and then we would issue a permit. Well, the first step before the permit is contractor's insurance. So general liability insurance is required for literally every permit that you obtain. And that's really a quick look at the demolition process. There's not a lot of detailed review because it's literally bringing a building down, so there's not that kind of detailed plan review. With a new building application, we are pouring through the plans. We would receive a set of drawings showing what the new building will look like, both visually on the outside, floor by floor, mechanical systems, plumbing, electrical, everything. Now the Department of Buildings reviews primarily for building code or the New York City construction codes, which includes building code, fire, plumbing, electrical, and so forth, as well as the zoning resolution, which is written by the Department of City Planning, but enforced by the Department of Buildings. So there are two ways an architect can file. They can file what we just call regular, which their application is filed. One of our plan examiners reviews the plans for conformity to code and zoning, or what's called professional certification. With professional certification, the architect submits his plans, but we're really only doing a zoning review. And the applicant is certifying that they've taken the care to do everything correctly, and this way their plan doesn't go through a full plan review. So there are also required items. Before we issue a permit, there's a set of required items that must be fulfilled. The first and the most noticeable, obviously, is the plans have to pass plan review. It's not likely that a new building application, even a professionally certified one, gets approved on its first plan review. There are so many items inherent to building a new building that it's very difficult, or I'd say very unlikely, that an architect gets everything correct on the first pass. So the plan review on a new building application can take, 4 to 6 weeks, to, I've seen some last a couple of years, because we will not approve a plan until every single applicable item of code and zoning has been met. In addition to that, before a permit's issued, we need the contractor's insurance. For many new buildings, project-specific insurance is required, where an insurer actually, looks at the project and the insurance policy is written specific to that project. So that's any job where excavation is 12 feet deep or more, or I should say at 12 feet or more, where the new building will be 7 stories or more, where there is a structure at the lot line, meaning a directly adjacent building. All those checkpoints mean they need project-specific insurance. So before a permit's issued, we're looking for that. In addition to the code and zoning plan review, we also have separate units that review other items. If excavation is involved, which is in almost every new building, our excavation unit reviews their excavation plans. They're looking for safety, code conformity, of course. They might, if the building is large enough, they require a site safety plan. So again, our best unit is looking at site safety. And these are plans literally about how they will maintain the site in a safe manner for both the workers and for the general public. So once all those approvals have been given, once the insurance has been checked and checked out, then we can issue a permit. And then the job takes on a life of its own, but we then have, an inspector may notice something on site that could cause a review, an audit, or oftentimes we receive questions about applications. Someone might say, well, I looked at the plans and this does not look like it conforms. So we can do what's called an audit, where we're essentially re-reviewing the plan, checking our own work to make sure that everything complies. Oftentimes, if we find an item that doesn't comply to code or zoning, which we may have missed in the initial review, we would then issue what's called an intent to revoke. That means that we've noticed an issue with the plans, and we may revoke the permit, but we give the architect a chance to correct what we call objections, to correct any non-compliant items. That's a little outside the permitting process, but the useful information. That's really the permitting process in a nutshell.
Go to a very important Brooklyn Bar Association meeting tonight, because I still am a lawyer, even though I don't have much of a practice, but I like to know all of the tricks and trades of the legal profession, just so that it sharpens me and I'm able to conduct my business as a legislator in a better way to help you. So thank you.
Thank you, Joe. I really appreciate it.
And by the way, I'm available now to answer any questions if anybody has one or two.
Oh, yes, please, before the Assemblyman has.
Yes.
I actually have a question. So, if the developer buys a landmark building and
Wait, what kind of building?
a landmark building,
Yes.
who actually changes that status from a landmark to that they can just turn around and convert it? I know it has to go through landmark preservation,
Yes.
but who okays that at the end of the day? And do the developers actually have to pay to get that landmark changed? We're talking specifically about the Green Point
They could
Savings Bank.
probably tell you more about that, but as far as what I know is that you have to apply to get your building landmark. This doesn't happen on its own.
It was a landmark, that's what I'm saying. They got it changed so they can convert the building to
Yeah.
condos.
And if you want to do that may require legislation by the city council, I'm not sure.
So they would have to go through the city council to actually change that. How would I find
As
that
I
out?
said, I'm not an expert on that, but I can check it out for you.
They have to go through the community board.
I'm sorry?
They have to apply, and it has to go to the community board, to the landmarks subcommittee of the community
Okay.
board, and then to landmark preservation.
So I would have to check the community board and see if they okay it.
That's right. I know there's a process, but I wasn't familiar with it off the top of my head.
Just to add my 2 cents, I've actually never heard of that happening, but it would be under landmarks, under LPC's discretion, from my understanding. They would have the sole determination for whether to remove a landmark.
So the actual bank is still landmarked, it's the commercial building that they're converting into condos. But they're also adding on to it, so I'll talk to you afterwards, because it's right next to my house.
I'll chime in, I'm sorry, I'll be speaking over you.
Nah, sorry.
But I'm not a zoning attorney under no circumstances, but what I was gonna add is, if it's a landmark building, it's probably the facade that they have to maintain. It's unlikely that it's a landmark building as a whole, therefore they can gut it out and they'll just preserve the facade of the building. Whatever they do on the inside, they can do based on the approval from the buildings department and LPC.
So they would approve it to extend it, because they're adding on to it.
Yeah, if they acquired excess development rights from neighboring properties, they could probably build it out as long as they meet the FAR requirements.
Yeah, that's what they're doing.
Any other questions? The Assemblyman?
Thank you, guys. Evelyn?
When a new building is going up, and like a lot of the lots are 25 by 100. Now, when they're building a building, aren't they supposed to leave 30 feet from, that space there? And there's supposed to be an egress, 2 egresses, front and back from the building, just in case, God forbid, there's a fire or any kind of, emergency.
Well, I'm trying to learn a lot of this stuff like you are, but, this is more in the province of the city council to understand some of these regulations, because they have to pass on legislation like this. So I'm not the expert that I ought to be, but what I can tell you is that the height of the building is often determined by the FAR. The FAR would be determined by how big the lot is. So, for example, I have a 40 by 100 lot that I own. So those folks could build higher than somebody who builds on a
Yeah,
25
they're
by
right.
100 lot. But I don't know what the dimensions are or how much egress or ingress is required. I'll leave it to the experts to tell you that.
I mean, you know of the case on Diamond Street.
Yes, I remember that case. Where they blocked everybody's sunlight and view.
Yeah,
I know that case.
but, the DOB didn't say anything about that case.
Well,
So I really
think we have a
in the
better-
future, that laws have to be really strict. Because with
well,
what's
as I
going
said, Evelyn, I've introduced a lot of pieces of legislation in the past when I thought we had a buildings department that wasn't following the rules correctly and helping the community.
Yeah,
And that's probably the case, but it was more of a problem back in the early 2000s when all of this development started happening and they were surprised by it. So, we have a buildings department now, and I'll say it again, that's more responsive to the needs of our communities. And I hope that that won't happen again, but, I've introduced state legislation because the city wasn't doing anything about it. And it's not my job to introduce legislation to affect directly the city of New York, even though I have the power to do so. We leave that to the city council. That's why we have a city council. Yes,
and I just want to say something else. Thank you for coming.
Erica?
Just a quick question, can you just elaborate a little of the burden of expense when there is a situation where say the building next to us decided to go, and we incurred damage and all sorts of stuff. A lot of people in this room, I'm sure, have had issues, but what's going on in terms of legislation to protect the person, the house that's affected by the other house in construction? Is it you incurred?
Well, that's what I'm talking about. I wanted that to happen, but generally, that's a lawsuit that's brought by the homeowner when he thinks he has to sue a developer in order to be compensated for damages that occur after the fact, rather than there being, and Ben can tell you if the building department has made any changes about how that takes place so that the homeowner who has property that's in jeopardy is safeguarded now. But at the time, when I introduced this legislation, there was practically nothing going on to help the adjacent landowner of somebody who was building.
All the policy changes, maybe it was good though too, like I said, there's a lot of predatory tactics against seniors. You all know it, you can make a wallpaper hanging from all the things that you get from developers. And I'm sure they play on the elderly deeds and all this stuff.
So you may have the inspiration for a bill that we can introduce in the city council or in the state legislature. And we can do that. Yes?
I don't live in this neighborhood. I have communicated with you online. My name is Ian Braun.
Oh, yes, Ms. Brown.
I'm in Fort Greene. But there is a difference between what the city regulations are and what exists at a state level that develops out of case law, actually, from lawsuits.
That's
You know,
right.
some of this stuff isn't written up as law, but because of court decisions, so the biggest problem is people don't even know what their rights are when it starts. And
Thanks to Victoria, we'll now know, because hopefully we'll get some information.
the problem. But in general, what people need to know is if there is an excavation occurring more than a certain depth, within 10 feet of the property line, there is an obligation to provide a legal agreement. So it might be a party wall agreement, it might be a license agreement. And the Department of Buildings is supposed to be aware whether such an agreement exists. And so sometimes the developers won't tell people, and DOB doesn't know, you need to, the neighbor needs to notify DOB. And that requirement occurred through state not legislation, but lawsuits. So that's what I'm saying. It's a mishmash of somewhat protection.
So what she's actually saying, let me capsulize that, and saying that law is not only found in a law book that says this is the law, it's found within cases that have occurred that are actually have the force of law, even though they're not written in legal form in a law book that says this is the new law of the state of New York. Is that correct?
No, I don't mean to cut anyone off, but if you have specific questions for what our state legislature can do that we can answer right now. If not, we do want to move on to the presentation so we can reserve the most amount of time to the Q&A. Please.
Thank you.
In the state legislation that you're proposing, will you consider the creation of an escrow fund actually funded upfront
Yes.
by the developer? Because before you get to offer permit, if you have to hire an attorney and you're a senior citizen with a building that's about to be damaged, struggling to keep your home and not become homeless, you're going to need to raise a substantial amount of money, and you may not be able to get a home equity line of credit fast enough or any other way. And we see that happening in Clinton Hill a lot. We're dealing with senior citizens who got fiber holes put through their walls, calling us and saying, what do I do? And we're like, well, we're not sure we can find you a construction attorney who works pro bono and you can't pay anybody. So here's all the experience that we've had to date, and we'll do our damnedest to find somebody to represent you for what you can afford, but you need that now. You're not suing, you're trying to get the DOB to comply with its own
that's a very good suggestion. Yes,
And just to add, liability insurance,
Yes.
which, I have found out, DOB, I mean, they have regulations, and, a lot of it has to do with the aggregate limit, meaning, obviously, if you're building a 20-story building, you need more liability insurance than if you're building, you know, a 4-story building. But nobody looks at the policies. So, for
to
instance,
determine whether or not they're
in
covered.
my case,
Mhm.
was an illegal exclusion. My foundation was damaged, we filed a claim. His insurance company did a 4-month investigation. At the end, they said, yes, our insured was negligent, and that's why you're damaged, but we won't pay because he had an earth movement exclusion. He was excavating. That's contrary to DOB regulation. But Ben also told me he referred it to licensing, but he would have no way of knowing if licensing actually would do anything. So some of it is structural issues, how one part of the agency communicates with another, and the other is insurance. I promise all of you, if you go home and look at your policies, you will have an earth movement exclusion. And it excludes all foundation damage due to earth movement, whether man-made or natural.
Yeah. I think that's a lawsuit waiting to happen against the insurance company to,
Yeah, you wanna come up with, you know, all that money? This is something, insurance companies are regulated by the state. The city can't do that. The city could demand that the developer and contractor show the policy and have a division that would review those policies. But what insurance companies are allowed to do
is
and
regulated by us.
sell is regulated at the state level. That is something the state could reform.
So
I've
that
heard
you,
problem all over the neighborhood.
Huh?
I've heard that from multiple people, the same issue.
Yeah, we discussed that at the Newhart meeting, if you remember that, Steve.
Yeah.
We discussed that, and that's
Yeah,
one of
but
the things.
DOT's stance is, once the damage has occurred, it's civil. So they're basically saying, we're doing our best to enforce the rules. If we overlook something and you're damaged, oh, it's your problem.
You'll find some information about, I mostly do litigation in the real estate development, so I look at everything from both from the developer's side and the affected neighbors. And so the way I'm gonna present this tonight is, let me take you a bit on a journey, because I wanna make sure you understand what the obligations are for the developer, what it is that he has to do, what his team, the design team and the contractor team has to put on before the buildings department, or with other filing agencies, and how he needs to work with you as affected neighbors. And maybe I'll try to respond to some of the questions that were raised earlier today as to how to shift the burden, how to respond and afford an attorney who's knowledgeable about how to structure these arrangements. But let's kind of walk through the agenda. What I'm going to focus on predominantly are going to be the construction license agreements. And for those of you who don't know what it is, it's basically an agreement that will allow the developer to come onto your property, to gain access to you louder. So the license agreements are basically another word for an access agreement. You need to have it in place oftentimes in order to erect some of the safety precautions on the neighbor's side, or to protect pedestrians and other people when there's means of egress involved. So I'm going to talk about what are the mechanics of it, what it means both from the developer's side and from the neighboring property owner as to what the risks are and how one can bring a lawsuit to force the neighbor to actually get a licensing agreement if there is a dispute between the neighbor and the developer. I'm going to talk about what to focus on as far as the license agreement terms are concerned and why it's relevant. And then what are some of the best practices that you should think about, whether you're on the developer side or on the neighboring residential property owners side. I'm briefly going to talk about property damage, and Assemblyman Lintel mentioned about there's a strict liability statute in place on the books. I'll refer to it and then kind of walk you through what potential causes of action you may have as a residential property owner. And lastly, there's something called the SLAP statute, which prevents or protects in certain ways those neighbors who complain against aggressive developer who may bring a lawsuit against you because you're voicing your concerns to the building department. And I'll talk about my commentary as far as it actually having two teeth here in the state of New York. So let's talk about the construction license agreement. Again, the license agreement is basically an agreement whereby the developer and his general contracting crew can come onto your property to install a sidewalk shed because it's required by the regulations. It may be because they're excavating over a certain depth or in a certain proximity to your building, and therefore the developer is obligated by the statute to enter into a licensing agreement and provide you with certain pieces of information. However, even though the developer is obligated to protect the neighboring properties, he cannot just come onto your property. He cannot install sidewalk shed, the bridges. He has to cooperate with the neighbors. So he cannot automatically come onto the property because that would be considered trespass. You as the owner are the king or the queen of the castle, but to a certain extent. And I'm going to talk a little bit about the regulation that exists in the Real Property Actions Law, Real Property Actions and Proceedings Law, Section 881. And that is when a developer wants to make improvements that will impact the next door property, he cannot make these and enter the premises, or there's a refusal to enter to allow him to enter. The owner, the developer, can go to court and start a special proceeding under the Section 881 in order for the court to issue an order granting a license for him to enter onto the property. So it's called a judicial order of license. And so there are circumstances when the developer may be forced to take this action. And I'm going to talk about what is the best way for a developer to work with you as a neighbor. Okay? But this is something that many developers will try to do, in that they will send a notice to you. And that's one of the things I want to make sure that you take away from this meeting is there may be notices that will be sent out by the neighboring developer. Do not ignore them. If you have the ability to bring it up to the attention of a construction attorney, raise it with a person, because that then determines the next sort of step that the developer may take. He may send you notices, he may reach out to you by email, contact you in person. It's important to have a dialogue, and it's important to focus the developer on developing sort of a common scheme, a common agreement that will allow him and his design team to come onto your property and protect you and your tenants, invitees who come onto your property. So there is also a mandate that is imposed upon the developer by the building code. And this is one of the things that the Assemblyman mentioned. This used to be part of the administrative code. Now it's, after it was recodified in 2008, there's information about the requirements for the developer with respect to the adjoining property owners in chapter 33, section 3309 has plenty of subsections that deal with the requirements for the developer, what it is that he or she needs to do, and how they need to go about protecting your property. An example may be, someone mentioned an excavation over 12 feet. Depending on what method they use, if it's not a step mat foundation, but they actually have to dig out a hole right next to your wall, and they'll be going below your foundations. That means if they come to the bottom of your foundations and they will be going beneath it, they have to underpin it. They have to create a protection for your wall. Whether it's a party wall or it's your own wall, that's secondary. But there are strict regulations as to what it is that the developer needs to do, and that will be an expense that he or she will have to bear. And what the developer is going to do is, if he's going over that certain depth, he's going to reach out to you and say, I need to have access to your property because I need to take photographs and video recordings of the conditions of the inside and outside of your property. It's called a pre-construction survey. And if you are approached by the developer or his representative or her representatives, make sure that you reference this pre-construction survey, because it's a photographic or videographic record of what your property looked like before any construction started on the neighboring property. And it has tremendous value to any litigator afterwards if any damage develops on your property. If there are cracks, there's someone mentioned subsurface movement. If there is, it could be something falling off your facade, all kind of things that we've seen. Cracks in the windows, whatever it is. Because that pre-construction survey will establish what your building's condition was before that demolition excavation began. And I cannot emphasize this enough, how important it is to people like myself who litigate these matters, where we find out about the damage after it's already occurred, and there's not a single photograph of the condition, either on the inside or outside of the building that was impacted. And it makes our work really difficult to recreate sort of that past. So when the developer comes onto the neighboring property owner, and he needs to have access to that property because he needs to do the pre-construction survey, there has to be some shoring, maybe, or some other protection underpinning. He has two options. He can negotiate a license agreement, an access agreement with you, or if you refuse, he's going to go to court. He's going to use that Section 881, and the problem that exists oftentimes is he only has to show that there's a temporary impact upon the neighboring property. It has to be a reasonable scope of access, and you're leaving this in the hands of judges to decide what the terms and conditions of that relationship are going to be. And oftentimes, judges are inexperienced with the construction process, they do not understand all the ins and outs and what needs to be done, what are the requirements from the building code or the building department. And some of the terms may be even left, again, to the parties to decide after the judge renders a decision. So, let's talk about what licensing agreement should be addressing. It should have, so let's talk about the main terms. If you are going to start having a conversation with the developer as far as the access agreement is concerned, the license agreement is concerned, you want to establish a certain period of time for duration of which the developer will have access onto your property. Depending on the type of construction that we're dealing with, it's going to be several months. If it's someone working just on the party wall, trying to make improvements, repairs, or if it's a new development, multi-story development, we're talking 18 months. It'll be part of the process of negotiating this with the developer. What are the protective measures that the developer will be required to implement for your property? Is it just a simple extension of a sidewalk bridge so that if they're working on a facade, there are things not falling onto the sidewalk or onto your side of the property, if it's a neighboring property. Is there, he has to put in a construction fence. There's a lot of little, is there shoring required? How deep is the excavation? How far it is away? Again, it's all fact driven. I can't really summarize it because there's so many protective measures that one can incorporate into the licensing agreement. Let's say he's building or she's building above your property. Do you want to protect your roof? Do you want to have netting over your property? Because they are excavating, there may be drilling or excavating, there may be vibrations that will be impacting the soundness of your structure. You can incorporate a vibration monitoring system into the licensing agreement and therefore impose upon the developer the cost of maintaining this vibration monitoring system, which you may have access to as well. So they will install a vibration monitoring device most likely on the lower end of your building, in the basement, if you have sub-basement, whatever it is. That little monitoring device will be feeding data into, most likely through radio waves, into some sort of a data collecting device. You can ask the developer to share that information with you through the licensing agreement. And then you'll be able to show it to your engineer as to what it shows, what are the deviations, were there any sudden increases in vibration at some point, and if they exceed certain levels, the buildings department has a clear information as to what was going on the neighboring property. The other measure that I always recommend is crack monitoring. If you have cracks in your building, if you have an older structure, they put little measures that they tape to the wall, wherever the crack is. And then if the construction progresses on the neighboring site, they see if the crack has increased or it has extended out, depending on which way the crack is going.
Sometimes the developers put the crack monitors up and they don't pull the tapes
Right,
out,
right.
and I think that's like one of their scams.
So, when I get to the last point, I'll respond to it, because this is, you raised a very good point, which is, I'm talking about how great it is to have an access agreement. But what's really important to the neighboring property owner is to have her own or his own design team, an engineer, professional engineer who understands the processes, or the architect. And what the access agreement, the license agreement allows you to do is negotiate fees, which means if you bring someone onto your team who can negotiate, or you can yourself negotiate this agreement, you can have the developer create either an escrow fund or an automatic payment whereby whatever invoices are generated by your professional engineer or an architect, the developer pays. And that, from perspective of, I think, people in the audience here, is the key component, I guess, of the licensing agreement I'm trying to get to.
I would just like, I have not heard you use the words licensed structural engineer. And my own experience says, you do not let the developer do the pre-construction survey. You say they will pay for the services for you to hire a licensed structural engineer to document your house and review their underpinning shoring and excavation plans. I will tell you, even that is no protection, because they go behind your back and amend the plans, but it's at least a start. I mean, you use the word design team. My point is, it's really a licensed structural engineer who works for you.
Absolutely, and that's what I mean.
And an attorney.
That's an excellent point, which is, in the whole process of development, maybe let me start from the ground up. There's a design team, people who actually create drawings and specifications that will show how the building is going to be developed, right? There are people from the design team, licensed structural engineers, or architects, some of them actually do this as well, who actually focus their practice on review on somebody else's drawings. And they get retained by residential unit owners or neighboring commercial developers to be on their team, which means they would be hired by you. And again, through the access agreement, you can shift their fees onto the developer who's trying to get onto your property. Is anyone with me? Everyone with me on that? Because that's a really important point. Because what you say is correct. Not for all the projects. I'm not saying, I don't mean to say that the developers are in any way dishonest, but to have a second set of eyes onto the project, what it is that their team is doing, be that the design team or the constructing team or the subcontracting team, it's good to have your own set of eyes, and those come in certainly handy. The other point that I want to certainly make is insurance and indemnification requirements, okay? So there's two aspects. One, you've heard Ben reference the insurance requirements, and I think there was a question from the audience about how the insurance should be structured. This is a key issue where you really need someone to know what it is that they're doing. Because the insurance requirement that the developer will have, it's called commercial general liability insurance. So whatever property damage occurs on their property, it will be covered. There'll be a base amount, an aggregate amount, there may be an umbrella policy, and maybe an excess policy. I'm getting too much into the weeds. But the point of this is, the insurance requirement that you can establish through the license agreement allows you to be added as additional insured onto the developer's commercial general liability policy, which means you can tap directly into that commercial general liability insurance. But there's 2 points. There's 2 points. Number one, you oftentimes have had probably the contractor come out and do some renovation on your property. You hired someone to do some work on your property. They gave you a certificate of insurance, which is a one-pager that tells you about their workman's compensation, commercial general liability insurance, if it's a design team, professional liability insurance, etc. But what I usually say is that the certificate of insurance that you get from their broker or from a particular contractor directly is worth as much as the piece of paper that it's written on. What you want to ask for is the underlying endorsements that are attached in the insurance agreement that comes with this commercial general liability insurance policy. And you want to have someone who's going to review it and make sure that there is sufficient coverage and exclusions that you referenced are not included, okay? And so that also is something that the license agreement allows you to do. The second thing is indemnification. Indemnification is basically an agreement to come in and repair whatever damages are done to your property. And that is an important point that you want to make sure makes its way into the licensing agreement. Because then it's sort of, and it's up to you how you want to do this. Do you want to have the team, the general contracting team that's working on the developer's site actually come in and do work on your site? Or if you want to retain your own team that will come and make repairs to your property. Again, nuances, but something worth exploring. So, these are some of the more nuanced details, which is, again, how long is this license agreement going to operate? What sort of protective measures are we going to have in place? How long is this construction going to last? And when are the protective measures going to be removed? Because if you have a sidewalk bridge over your property, and let's say it's over your garage or exit, you don't want to be coming out of your house with a sidewalk bridge over your head for 2 years. You want to have a predetermined amount of time that's going to define when they're going to take it out. And you can do this with a licensing agreement. Same thing about the insurance. Now, this is the really interesting part, which is the negotiated fee basis. 2 aspects of this. When I mentioned the real property actions and proceedings law, section 881, there's a split in courts right now, and whether or not the impacted neighboring property owner, so the person onto whose property developer wants to come in, is entitled to a monthly fee. In other words, we've seen cases recently where because, let's say, the construction next door lasted 18 months, the court, through this proceeding, awarded the neighbor a set amount of money because there was some sort of a restriction on the use of a parking space, balcony, roof, and there were funds that were paid to the neighbor monthly in excess of $1,000, as an example. But the negotiated fee basis is the ability also for you to define who you want to have on your team, who's going to be doing the review. If you want to have a structural professional engineer, who's going to pay and how. And lastly, can you set up some sort of an escrow for any automatic deduct because you're incurring certain expenses or you have to undertake certain repairs. Okay, so let's talk about some other things that should be a part of a licensing agreement. The developer is on a set schedule. He or she wants to get done with their development as soon as possible, whether it will be a mixed-use property, so commercial and residential, whether it will be rentals or it will be a condominium. You want to make sure that it's part of this licensing agreement. If there are drawings and specifications, there was a reference, I think, to support of excavation drawings, they are required to give you a copy of it. And then you can have your structural engineer review them. Is there going to be a pre-construction surveying and post-construction surveying? What sort of monitoring devices are you going to have installed on your property? And who's paying for the engineers, for your attorneys, and for whatever remediation costs there are because there's damage to your property? And this is an important point. I mean, my point of work, it wouldn't, it normally would, not on the TV monitor. But through the license agreement, you can actually shift the costs of attorneys' involvement onto the developer. And there's two aspects of it, because we kind of always think about development in a sense of ground up build out, right? Or expanding an existing property, as someone mentioned, I believe, the landmark preservation building that was being built on top of it. But there's also local 11 law. I don't know whether you are familiar with it, but if you are in a building, I believe 6 stories and higher in New York City, you're required to maintain the facade and the exterior of the building. The pointing, the caulking, and making sure the bricks that are spoiled get replaced. So as part of the local law 11, which is imposed upon the buildings 6 stories and higher, every 5 years, the cycles are, every cycle there has to be a review and certification by an engineer hired by that building that either building meets the requirements or it requires certain repairs, et cetera, et cetera. And because these local law 11 work is undergoing, they may need to erect some protective measures over your building. There'll be probably a minority of maybe people impacted here, but it's important that that's when the neighbor who's doing those repairs may come in and say, look, I'm sorry, I'm going to create some sort of a sidewalk shed, some form of a protection over your building. I'll need to throw some sort of netting over your roof. Can we please do a licensing agreement? Because I want to make sure we do our repairs quickly. That is also a licensing agreement because they are coming onto your property. They're getting a license to use and access your property, subject to the terms that you agree. You also may want to consider is something called liquidated damages. This is a predetermined amount of money that you will agree with the developer that if he or she does not complete work by a date certain that we talked about early on, he or she will have to pay you monthly an amount that is not a penalty, but a reasonable replacement cost for the nuisance that some protective measure is creating onto your property. An example, let's say during the demolition, when they're taking the warehouse next door to you, they erect a sidewalk bridge and they'll set it up in a way that if by the end of December the demolition is not completed, all these protective measures are taken off your property, you will be entitled to $1,500 or more dollars a month. So there's an incentive for both sides, for you to see this protective measure taken out of your building and for the developer to complete the process sooner than later. What are the requirements to repair the damages? If there's any damage to your property, you might want to define this. What protective measures? If it's really important to you, you can obviously make this agreement confidential, and there may be a variety of reasons why you want to make sure that this license agreement becomes confidential. Is there any security requirements that will be part of the process, because you might want to ask for a security guy who's guarding their property to be also looking over your property. And there's a lot of scenarios that we can think about. How is the review and sign-off process going to be handled? This is also an important one. If you negotiate the fees and they pay for your engineer or your architect, then your team, your design team, can actually look over their drawings before they get filed, and they can provide comments. And you can structure this arrangement in a way whereby, again, the developer pays for that process. And again, shoring and waterproofing. So as you kind of go through this, and you've heard a lot from me already, think about the things that will be important to you. And again, I cannot underemphasize the importance of having someone who understands the process be a part of this. And what I mean by this mostly is an engineer or architect who's familiar with the process. Because at the end of all of this, be realistic. Because what I see oftentimes is a condominium next to which there was one of the New York public libraries being renovated, thought that the impact of the construction upon their property was such that they required $15,000 a month. And it's just simply an unrealistic expectation, because the developer is going to say, no, I'm not going to agree to that term, and I'm just going to go to court and sue under Section 881. Okay? So just bear that in mind. It's not about being opportunistic. It's not about being obstinate in a certain way, but thinking through all these terms that I talked about, which is, how do I protect my property before demolition excavation starts? What happens afterwards? What's the process with the review of the drawings? That should be part of your analysis, because at the end of all this process, you're trying to reach an agreement. And I cannot underemphasize this, that you have to approach this not the developer or my neighbor is my enemy. I'm trying to reach an accommodation. It's a compromise. I'm going to give some, he's going to give some, or she's going to give some. I'm going to agree to this. There's certain things that are mandated by the law, but at the end of the day, you're trying to reach that gap and try to agree on these terms. Because it's going to be easier for the developer to pay extra amount of dollars than go to court and wait for the court to decide, because sometimes these proceedings take longer. And so that is one of the overarching things. Questions that were raised today were about property damage. What happens when there's a damage to your property and it's caused by the construction that's occurring next door? I believe Assemblyman Lintel mentioned the strict liability statute. This is the section 3309.4 talks about soil foundation work which affects adjoining property owner. And so if there is damage, there's cracks, there's collapse, partial collapse, whatever the case may be, the next door property owner will be strictly liable, which means all you need to show is that there's damage and some connection between his construction activities and your property. I don't have to show that they were negligent. And that is really a helpful distinction, but there's one important point. There had to be an agreement whereby you, as the neighboring property owner, afforded a license for the developer to come onto your property. Okay? So that is the built condition. If the developer came to you and sent you the notice and said, look, I'm going to be building next to you, I'd like to enter into a licensing agreement, make sure that you respond to that letter. Make sure you take steps to reach that accommodation, whatever it is. Because at the end of the day, this provision really helps you a lot. It really cuts the process tremendously. It's still a litigation, there's no doubt about it. But this really helps to shift the burden, and it really is an aid to the neighboring property owner. Let's talk about people who voice out their concerns about what's going on the next door property. These may be residential unit owners who don't know what to do, and they go to the buildings department, they call 311.
I'm sorry, I just want to go back before you go on. You said
Sure.
it's still in litigation. What does that mean? It's not a solid litigation, or it can be litigated?
This will have to be litigated. The idea here is that it's designed to address the issues that you, as the person who's suing the next door developer, you have in a sense an easier time proving your case. I would have to somehow gradually explain this to you. But it is a shifting mechanism that's very helpful to the affected property owner. Yes, it has to go through litigation. And certainly there are firms who do this. But going back to this, sort of my last point tonight, there's a statute called Strategic Lawsuit Against Public Participation. And it has not been really utilized here in the state of New York. We've started recently looking at it. And if there is one piece of legislation I would probably try to get your elected official to look at is this statute, particularly for those residents who cannot afford representation, but are vocal and will go to the buildings department, will go to call the 311, and they will make a complaint because the next door developer has obtained a permit and is building something out. And you don't know how to defend against that. And instead, what the developer does, because he or she can afford it, they will sue you because they consider you a pest. I'm sorry, but that's how they look at you. And for them, it's just a cost. And they will try to start litigation because they want to make sure that you stop making the complaints. This statute is designed to address these issues, but unfortunately in the state of New York, unlike other states, for example California, in my view, it needs someone to protect the residents from any sort of litigation on that side. And I'm going to end on that. And I'm happy to take questions.